Hi, my name is Marc Atas. I'm from the law office of Marc Atas and Associates. I'm located in Baltimore, Maryland. My phone number is 410-752-4878. I've been doing workers' compensation claims since 1980 for approximately 38 years. Question I often get from clients is, can I sue my employer for being injured on the job? And the simple answer to that is that there is no simple answer. The normal general rule is you cannot sue your employer, but you can file a workers' comp claim. So let me just explain. Back in the early 1900s and before that, if you were injured on the job, your only remedy if you got hurt on the job was to sue your employer. And obviously that was not a good situation because, one, lawsuits can take years. It creates bad will because this is someone you're working for. Employees can't afford to be out of work and not being paid, and most of them couldn't afford medical treatment and didn't have health insurance. So the workers' compensation system was developed, and basically it was a compromise between government, unions, management, and labor, where they agreed to the following. We will set up the workers' compensation system. It will be a system where the employee will get paid relatively quickly for any lost time from work. Their medical expenses will be covered, and they may get some sort of a settlement as far as a permanent injury award and vocational rehabilitation. But in exchange for that, they're giving up their right to sue their employer. So the workers' comp system is a substitute for the tort system where you have a right to sue your employer. And that's basically been the law since the early 1900s. And most of the time you will hear from most lawyers, you cannot sue your employer. Now, there are limited situations where you can sue your employer, but the general rule is you can't. So what are those limited situations? So if your employer is the one that actually hurt you, they're the actual tortfeasor. They're the person that caused the injury to you directly, not by ordering someone else to do something or not by their negligence in having someone else do something or not do something, but the employer actually committed the act themselves, then they can be sued. So the classic example is if you are working on the job and your employer hires Fred, who's your co-employee, and Fred is driving a vehicle and you're in the company vehicle with Fred, and Fred is involved in an accident and causes the accident, Fred's at fault. The only remedy you have in that case is two. One, you could file a workers' comp claim against your employer. And if Fred has his own car insurance, you may be able to file a claim against Fred because he's the one that injured you. He was at fault in the accident. However, you could not sue your employer, the guy you worked for, because your employer wasn't the one that was driving. He's just the one that hired Fred. He's not the direct cause. However, if in fact, let's say your employer, let's say you work for Fred, he's a company, he's a sole proprietor, Fred's driving, and you're employed in his vehicle, and Fred has an accident. In that situation, you can actually sue Fred, as well as filing a workers' compensation claim against Fred, because Fred is the one that was negligent. He's the one that was driving at the time, so he's the direct tortfeasor. So in the situations where the employer is the actual negligent party, and I don't mean he negligently hired someone, but he negligently did an act that led directly to your injuries, then yes, you can sue your employer. Other than that, no, you cannot sue your employer for anything that they've done as a supervisor or something they failed to do that caused injury to you because of something someone else does. It has to be something the employer directly did themselves. In those situations, you can. So most of the time, no, you cannot sue your employer. However, you still have the remedies of workers' compensation. A lot of the remedies are similar to what you would get in a suit where you were filing a tort claim, including lost wages, medical expenses, and a settlement for your permanent injuries. What you're not going to get is what you would normally get from directly suing someone is a pain and suffering award, which is different from the permanent injury award, although there's some similarities. Something you might get that you wouldn't get in a lawsuit is you get the open medical treatment for the rest of your life. In a lawsuit, once the case is settled, your case is settled. Any treatment after that is on your own dime. In a workers' comp case, it usually stays open. So there's some advantages to a workers' comp claim over being able to sue someone and there's some disadvantages, and sometimes the tort system where you can sue them, where you can collect pain and suffering, if that's a big part of your case, then that may be the better system. If you have any other questions about whether you can sue your employer or not, or what you can collect from being injured on the job, you can always call me. My name is Marc Atas. My phone number is 410-752-4878. I'm from the law office of Marc Atas and Associates. I'm located in Baltimore, Maryland. Thank you for listening.